Okay, thank you so much. And good morning, everyone, and welcome to our first webinar of 2023. And this really rose out of the floods and the devastation that was caused in KZN last year, particularly in the coastal regions, with excessive rainfall and the consequences of excessive rainfall. And we decided to look at the 4 standard forms of contract that we use typically in the construction industry in South Africa, and how they deal with extensions of time in the case of natural disasters. I think with the emphasis on abnormal climatic conditions, rainfall, global warming, those sort of issues. I mean, we've seen very recently a prime example of the devastation that natural disasters can have with the earthquake that struck Turkey and Syria on Monday, and the death and destruction that caused. So natural disasters are around and they will continue to be around. But we have a real fear in the future, or a real problem in the future of things like the impacts of global warming and localized flooding, those sort of issues. So I'm going to start off by talking about the GCC 2015 and how it deals with extensions of time in the case of natural disasters. Under the GCC, the contractor has certain obligations. Under clause 2.1, dealing with available data and information, the contractor is deemed to have inspected the site and studied all available information pertaining thereto before submitting his tender. It's assumed then the contractor shall be considered knowledgeable in respect of environmental, hydrological, and climatic conditions. Furthermore, the contractor shall in general be deemed to have obtained all available information on risks, contingencies, and all other circumstances which may influence or affect the works, couched, of course, by the statement that as far as is reasonable. And clearly, the definition of reasonable and reasonability is sort of depends on, varies from person to person. So he certainly has an obligation at time of tender to try and satisfy himself as to all the available information, including climatic and hydrological conditions. Under clause 8.2, the contractor has an obligation to take care of the works. From the date the site is handed over until the issue of the certificate of completion, he takes full responsibility for the care of the works, plant, and materials on site. And under the GCC, plant is equipment and things to be actually incorporated into the works, and not the contractor's own plant. Furthermore, during this period when he has care of the works, if there's any damage or physical loss from any cause whatsoever, other than the accepted risks under clause 831, the contractor shall at his own cost repair and make good the same. So what we're saying here is if there's damage to the works through flooding, through other natural causes, the contractor has the obligation to repair the works at his own cost, which clearly is a major obligation. So how do we get around that? Well, under clause 8.6 deals with insurance of the works, plant, and material on site. So except if otherwise stated in the contract data, the contractor shall, before commencing the works, and at his own cost, effect and maintain the following insurances in the joint names of the contractor and the employer. In some instances, the employer will take out insurance themselves, particularly when they've got multiple contractors working on a site. It makes sense to make sure that the insurance is uniform across the site, and there's not one contractor that hasn't taken it out or has taken out a policy with less limits of liability and those sort of things. So the contractor in this instance is responsible to take out insurance of the works, plant, and material on site against damage or physical loss arising from whatsoever cause, but not the accepted risks, for the period for which the contractor is responsible for the works in terms of clause 8.2. The accepted risks are normally occurrences that are uninsurable. So those would be exceptions in the insurance policy. And hence those risks are passed on to the employer, but only to the extent that they cause physical damage or loss to the works. So a contract works insurance policy is there to cover sudden and unforeseen damage or loss. It can be taken out on an annual or a project-by-project basis. There are exceptions as to what types of works are covered. A contract works policy will not necessarily extend to marine works. You might have to take out a particular policy there. Nuclear works, those sort of issues. So it depends on the type of work you're being undertaken as to what the policy will cover or not cover. The policy will have a limit of indemnity, typically the value of the works. It could have a contract escalation clause because you're insuring the works at the time of tender or the time of contract award. And if the contract is over a time period, then the costs will clearly escalate. There could be post-loss escalation. If you're doing work in foreign currencies, there could be a devaluation clause to help you with your limit of indemnity. It could also cover professional fees if you've got to redesign parts of the works. And it also covers, to a certain extent, costs the contractor may incur in putting his insurance claim together. There's a deductible and excess, which is applied to each incident. Principal cold insurance policies, the excess can be quite significant. For instance, on the power stations that Eskom was building, I think the excess on the contract works policy was 2.5 million rand. So which is quite a big excess for a contractor to carry. The contract works policy says it will cover loss or damage caused by a storm, including hail, rain, snow, tempest, water damage, flood, subsidence, collapse, or earthquake during any one period of 72 consecutive hours. So if it rains for 72 consecutive hours, they'll only apply, if it rains on and off for 72 consecutive hours, they'll only apply one excess to the occurrence. It will typically cover any costs incurred in the dismantling, demolition, clearance, or removal of silt or water or debris or wreck of the property insured, and providing, erecting, and maintaining of any hoarding, fences, and similar structures required in making good or restoring the site. So it covers any costs incurred in restoring the contract site, in regaining access to the contract site or the works and restoring normal working conditions, in complying with the requirements of the contract or any statutory body, and then in protecting the property against further loss or damage following upon any loss or damage of which indemnity is provided by this policy. So you see that the policy is quite all-embracing. It really pays you for the direct costs of reinstating the works and some of these indirect costs, such as removing silt, water, debris, restoring, gaining access to the site, restoring the site, etc. Under the policy, the insurers made their option repair, replace, reinstate, or pay cash in lieu of repairs. So the insurer has the option to decide what he wants to do. Clearly, it excludes liquidated damages or penalties for delays. So if the occurrence pushes you into a penalty situation, the policy will not respond to that. It also excludes consequential losses of any nature. So it doesn't pick up the consequences of the natural disaster, but only the damage or loss caused by the natural disaster itself. And then it has some exceptions. And these are normally on roads jobs and trenches jobs. So unprimed base course typically will have an exception that says damage arising from any one loss is limited to a maximum of 5 kilometers in any one section. Open trenches, loss or damage or liability due to flooding or silting of pipes, trenches, or shaft up to a length partially or completely excavated of 5 kilometers, any one loss event. And with open trenches, it goes on to say that the pipes should be capped and made sure they're secure and can't float and all those sorts of things. So a contract works policy is an important component when dealing with natural disasters. And this is where the contractor is going to recover the costs of reinstating the works, which is his obligation. So under the GCC, a contractor claims in accordance with clause 10.1 when he's claiming an extension of time for practical completion. Some grounds for an extension of time are additional work, abnormal climatic conditions, other provisions of the contract which allow for an extension of time, and any disruption entirely beyond the contractor's control. The critical path must be effected, and the extension of time shall take into account special non-working days and all relevant circumstances, including concurrent delays or savings in time which might apply. And the contractor carries the risk of normal climatic conditions. It begs the question is, what is normal nowadays? So if an extension of time is granted, clause 512.3, the contractor should be paid such additional time-related general items included for special non-working days are as appropriate. Under the GCC, if the contractor is entitled to an extension of time in accordance with clause 512, he's automatically entitled to additional payment, subject to the provisos of clause 512.1 and 512.3. This is not the case in other standard forms where extensions of time and entitlement to payment are separate issues. So if we look at the word abnormal, it says not normal, deviating from the usual or typical, extraordinary, aberrant, anomalous, atypical, exceptional, irregular, preternatural, strange, unusual. And unfortunately, unless there's some form of objective measure specified in the contract, what is considered as abnormal becomes subjective. And in the past, the accepted definition of abnormal was occurring less frequently than once in 10 years. But I mean, now with global warming and weather phenomena such as El Nino and La Nina, what is considered normal? Will the exceptional become the normal? The focus here, as I said previously, is primarily on rainfall. But what about flooding, wind, excessive heat, as we've seen in the Northern Cape, where some farm workers died through heat exhaustion, and cold? I mean, look at North America when it was hit by that polar freeze recently. And these things are becoming more and more prevalent. So typically, to avoid the subjectivity around what is abnormal, most contracts will contain some sort of rainfall formula. This is typically one that you can find in the GCC. It's a calculation that calculates an extension of time, where V is the extension of time in calendar days for the month under consideration. NW is the actual number of days during the month in which rainfall of 10 millimeter more is recorded. RW is the actual total rainfall in millimeters recorded during the calendar month. NN is the average number of days derived from rainfall records in which a rainfall of 10 millimeter or more was recorded during the relevant calendar month. And RN is the average total rainfall in millimeters for the relevant calendar month derived from rainfall records. So again, the average is the contractor's risk. Above the average then becomes grounds for an extension of time. Another important point is that the climatic conditions themselves that must be abnormal. There's no provision in the GCC to cater for any consequential delay, either in relation to an extension of time or additional costs incurred. Clause 2.2 in the GCC, which is adverse physical conditions, expressly excludes the weather conditions on the site and the direct consequences of those weather conditions. While the cost of rectifying any damage or direct loss may be recovered from insurers, unfortunately, the consequential costs are not. And what is important is that the time for assessing the delay is when the work was actually done, not when it was programmed to be done. I'm sure some employers like to pull the ploy of saying, well, you actually programmed to do this, you're late, you actually programmed to do this work during winter, then there shouldn't have been any rainfall. So therefore, you're not entitled to an extension of time. But clearly, the time for assessing the delay is when the work was actually done. And then what about concurrency? The GCC says we must take concurrency into account. And the GCC 2015 guide goes on to state that if a contractor's delay occurs at the same time as an employer delay, we're talking about concurrent delay, and the employer delay is caused by a risk or event allowed for in the contract as an employer's risk, then despite the concurrent delay for which the contractor is responsible, an extension of time must be granted for the employer's risk causing the delay. Quoting the Malmaison judgment, which the employer's delay being the relevant event. For example, abnormal climatic conditions versus a breakdown in a critical item of plant belonging to the contractor. But now we've got to certainly look outside the contract. I mean, what about supervening impossibility? the subsequent damage to the site or the surrounding infrastructure makes it impossible to perform what we call supervening impossibility. Well, that event is normally classified as either vis major or causus fortuitus, which is really any happening, whether due to natural causes or human agency, that is unforeseeable with reasonable foresight and unavoidable with reasonable care. The event must render performance absolutely or objectively impossible. Supervening impossibility then discharges the contract. So the contract comes to an end. The parties are released from their respective obligations to perform. In that instance, then, how is payment dealt with? Well, probably that the contractor is entitled to be paid up to the time that the event occurred, which made carrying on with the contract impossible. But after that, since the contract has come to an end, he's not necessarily entitled to any further payment. Partial impossibility, or just simply because it's more difficult to perform. Well, if it's partially impossible, you have two sort of options. The one is where the obligation is divisible from the contract. So the obligation which becomes impossible to perform is easily divisible from the contract, or the obligation is not divisible when it becomes impossible to perform. In the first instance, then, the impossible part is discharged and the balance remains in operation. So you just excise out the part that becomes impossible and carry on with the remainder of the works. In the second instance, the employer may elect to cancel or accept the reduced performance in exchange for a reduced counter performance, some sort of bargain. And the fact that vis major or casus fortuitus have made it uneconomical for a party to carry out its obligations does not mean that performance is impossible. And again, how is payment dealt with? So if, for example, that the direct access to the site has been washed away and the contractor now has to take a roundabout circuitous route of 5 kilometers to get to the site, it's still possible to perform, but clearly it's become more expensive. And how does he recover those costs? Can he recover those costs under the GCC or under common law? So in future, clearly natural disaster, particularly climatic conditions, are going to become more and more prevalent. So should conditions of contract contain express terms for dealing with the effect and consequences of abnormal climatic conditions? Should we be putting clauses and terms in place so that when they happen, we've got clear guidelines in the contract as to who bears what cost and what the rights of the parties are when these occurrences happen? And should abnormal climatic conditions become an accepted risk as perfidic, where the contractor is entitled to an extension of time and his cost? Under the GCC, he is entitled to extension of time and cost, but not necessarily under other clauses. Or should abnormal climatic conditions be treated as a force majeure occurrence? I mean, clearly, they're beyond the control of both the employer and the contractor. So should it simply be a matter of the contractor is entitled to time, but no cost, since hopefully he's got an insurance policy that's going to cover certainly the majority of the costs he's going to incur in reinstating the work? And then insurance cover is for sudden and unforeseen loss. So just by way of example, I mean, in 2008, I think we had load shedding for the first time. So clearly that was a force majeure occurrence, and no one could have foreseeably seen it happening. My apologies, my telephone just went off. No one could have seen that happening, so it was clearly a force majeure occurrence. But the second time load shedding happened, and the third time, and the fourth time, was it still sudden and unforeseen? The flooding in Durban that happened March, April last year, that was sudden and unforeseen. If it happens again in a year's time, can it still be classified as sudden and unforeseen loss, or will insurers looking for ways out of paying? Will insurers start to limit or decline cover in the event of abnormal climatic conditions? For instance, in the United States, certainly in the southern states, where hurricane insurance is taken out, it covers wind damage, but not damage by water from flooding or storm surge. You have to take out a separate policy. And clearly the big argument when insurers send out assessors is, was the damage caused purely by wind, or was it caused by flooding and storm surge, or was it a combination of both? And who pays out what? And so again, we need to look at our policies closely in future. So in conclusion, probably two things to take away from this is, number one, as we've said all along, know your contract. And number two, know what your insurance policy covers. Thank you very much. Any questions?
Norman, I see David had his hand raised. So
Yes.
David, I'll allow you to talk perhaps if you have a question. Okay, I see David is muted. David, if you want to unmute yourself. Okay, I'll just go to the next one, Lefuno.
Morning, Tiffany. Morning, Mr. Milner. This is not a question to say, but I just wanted to break it to the attention. On the link that we received notes on the natural disasters based on the FEDEC and not the GCC. Just wanted to find out if we'll be getting this.
Yes, no, we'll send them out after this session. They'll certainly come out. Yep.
Thank you very much.
Okay, I see Mike has raised his hand. Mike, I'll allow you to speak if you have a question.
Hi. Yes, Norman. One instance where none of the contracts actually deal with satisfactorily is when the insurance is taken out by the employer.
Yes.
And I've been specifically involved in a dispute where the insurer had his own assessor, and the assessor came to site and he said, well, that's how much we're going to pay, and that's it. And the amount that the insurance was going to pay out was not adequate to cover the costs of restoring the works. So there's a big gap there's a big potential gap over there, because there's nothing in the contract that states that the contractor can claim.
Yeah.
And another big gap, but another big potential gap, is where the employer's agent or the engineer actually expects the work to be restored in a certain condition, which will cost the contractor more than what the insurer is likely to pay out.
Yeah. No, you're quite right, Mike. And I mean, clearly, if the contractor has to negotiate with the insurer. I mean, that's the only thing you can do. And often, I mean, the loss assessor has the last say. And if you want to take on the insurer, then you've got to actually go after them in court.
But yeah, but there should be some provision somewhere.
Yeah.
Maybe in the bill of quantities, in the preliminary items, to cover these discrepancies, because those discrepancies are not of the contractor's making. The contractor has no option unless the contractor takes out additional insurance to cover the gap.
Yeah.
Otherwise, the contractor just has no choice. And if the employer has an insurer which is of questionable repute, as has happened a number of times, then the contractor is left between a rock and a hard place. So I'm not sure whether there is something that can be provided for in the contract clauses where the contract deals with insurer or some insurance, or something that gets entered into the contract data. But I think it is becoming more and more prevalent as an occurrence where there is a big gap between what the insurer pays out and what it costs the contractor to actually restore the works.
Thanks, Mike. Thank you.
Wanted to see you are able to talk if you unmute your microphone if you have a question. Okay.
Okay.
We can always go back to that. Perfect. All right. So I think up next was Vaughan. Is that correct?
Yes.
Okay. Wonderful. Vaughan, when you're ready. Okay. I'm not sure if Vaughan is struggling on his side. Should we? Oh, there we go. Okay. Okay, Vaughan, yeah, you're just on mute and you can put your video on. Okay. Perhaps we can continue with Reg, and then I can assist Vaughan in just getting his system working on his side. So Reg, are you happy to, you're also on mute, Reg? I'll just, there we go.
Can you hear me?
Yes, perfect. Thank you.
I've got to find this.
So just go click on the share screen button.
I just did that.
Okay. And then if your
But
PowerPoint,
there's nothing coming up here.
was your
Just-
PowerPoint open?
Let me check. Yeah, it's open. Can you see anything?
No, nothing yet.
It is open.
Is it open on a different screen?
I'm not sure what you mean.
So if you click the share screen button, the
Yeah.
window pops up, does that PowerPoint not show as being one of the applications open?
No, it doesn't. Didn't I say share? No, that didn't help.
Okay, yeah, no, that's perfect. If you go to your PowerPoint now.
Sorry, I don't know what's going on. Oh, no, I'm back into my.
You can just close your Outlook and you can go to your PowerPoint. Okay, we can see your computer screen. So now just open the PowerPoint. Yeah, there we go.
You got it.
Yes, perfect.
All right. Okay, I've taken. Let me just maximize this.
Perfect. That looks
Okay.
good.
All right. I've taken a broader brush view than Norman did. That if you can see that, dealing with the natural disasters under the FIDIC 99 conditions of contract. I tried initially, I had considered addressing both FIDIC 1999 and FIDIC 2017, but it was almost impossible to do it in the same presentation in the time, because there are very big differences between them in certain instances. So I decided to focus only on FIDIC 1919 because, as I understand it, my perception is there's been a very slow uptake of FIDIC 2017 anyway. And I think most disputes being encountered are still around the FIDIC 1999 conditions. Right. So I just want to get rid of this little side screen that's annoying me. Sorry. I can't get rid of it. All right. Just as I was saying, I'm staying with the FIDIC 1999. It's the same for the red and yellow book, essentially. The FIDIC guideline, I was looking at the force majeure, and I was also looking at the employer's responsibilities. And the FIDIC guideline says that it's just interesting stating this, that the statistical analysis in events is based on historical records to determine whether an event is reasonably foreseeable. The example given is if time for completion is 3 years. Sorry, I must try and get rid of this sidebar. Okay, there we go. If the time for completion is 3 years, an experience contract might be experienced to foresee an event which occurs on average once every 6 years. But an event which occurs only once in every 10 years might be regarded as unforeseeable and so as to constitute force majeure. Now, it would appear that there are conditions that could arise that are not necessarily force majeure, but would require the would have to look at unforeseeable conditions, and the engineer would then have to make a determination. Man, these bars are calling me. Okay, so in this case, force majeure, to look at force majeure in the first place, force majeure means an exceptional event or circumstance which is beyond a party's control, which a party could not reasonably have provided against before entering into the contract, which having arisen, such party could not reasonably have avoided or overcome, and which is not substantially attributable to the other party. And I think what does arise here, when taking into consideration the consequences, whether they're foreseeable or unforeseeable, would go around C and D, and to a large extent, I was interested in what Norman was saying as to how the contractor would have to show that he had taken sufficient cautions or precautions to prevent flooding. So I think C and D here, for it to be a force majeure, the contractor would have to demonstrate that he had taken all precautions against reasonable flooding, and therefore it could not be attributable to him. Sorry. So we also then look at the employer's risks under clause 17 and 17.3. Employer's risks, the first ones here, war, hostilities, etc., rebellion, terrorism, sea riot, commotion and disorder, munitions of war. These are all, and as I'll show you later, these all constitute force majeure. However, there are things like pressure waves caused by aircraft that, interestingly, are not covered under the force majeure clause. But this particular clause here under as employer's risks is designed as a part of the work by the employer's personnel or others for whom the employer is responsible, and also use or occupation by the employer of any part of the permanent work except as may be specified by the contract. But what is pertinent here is any operation of the forces of nature which is unforeseeable or against which an experienced contractor could not reasonably have been expected to have taken preventative measures. And that's why I was referring earlier to the contractor having to take reasonable measures. And if he had taken reasonable measures, of course, it wouldn't have happened. If it can be shown, and under clause 4, which I haven't listed, the engineer can actually inspect the site to determine whether in his opinion or her opinion, the contractor had taken sufficient precautions against flooding. The consequences 17.4 of an employer's risk. Sorry, I'm sorry, and my slides keep jumping around with all these bars on. I can't get rid of them. So if and to the extent the risks listed in 17.3, this is the employer's risks now, the above results in loss or damage of the works, goods or contractors, etc., the contractor shall promptly give notice to the engineer and shall rectify this loss or damage to the extent required by the engineer. If the contractor suffers delay and incurs costs from rectifying this loss or damage, then the contractor shall give further notice to the engineer, and subject to subclause 20.1, shall be able to claim for an extension of time under clause 8.4, or to payment of such cost, which shall be included in the price. And then, in the case of subparagraphs F and G of subclause 17.3, he shall be entitled to profit on the cost. So if we go back to those, these are the points G and F, whereby the contractor could claim for profit on those as well if those costs were allowed. Just going back to where we were, after receiving this notice, the engineer shall proceed in accordance with clause 3.5, which is determinations, to determine or to agree to these matters. Going back to 8.4, just looking at what is covered under extension of time, the contractor shall be entitled, subject to clause 20.1, to an extension of time for the time to completion, and listed under that is exceptionally adverse weather conditions. Clause 20.1, the relevant parts, if the contractor considers himself entitled to an extension of time for completion and additional payment, the contractor shall give notice to the engineer describing the event, circumstances giving rise to the claim. The notice shall, as soon as practical, but not later than 28 days after the contractor became aware of or should have been aware of the event or circumstances. If the contractor fails to give notice within 28 days, the time for completion shall not be extended, and the contractor shall not be entitled to additional payment, and the employer shall be discharged for all liability in connection with this claim. Otherwise, the following conditions shall apply. The contractor shall keep contemporary records as may substantiate the claim, and within 42 days after the contractor became aware of the event, the contractor shall send to the engineer a fully detailed claim, and within 42 days of receiving the claim, the engineer shall respond with suitable comments. Each payment certificate shall include any amounts for any claims that have been reasonably substantiated, and the contractor shall only be entitled to payment for such part of the claim as he has reasonably been able to substantiate. And the engineer shall then proceed in accordance with clause 3.5 to determine and to agree to whether it's an extension of time and or additional payment. So what then constitutes force majeure under the FIDIC conditions of contract? I listed these previously. It must be beyond the party's control, not reason. Such party could not reasonably have provided against, which having arisen, such party could not reasonably have avoided, and which is not substantially attributable to, sorry, that's to either party, not the other party. Force majeure may include, but is not limited to, exceptional circumstances, the kinds listed below. And then we go back to things like war, hostilities and invasion, rebellion, terrorism, riot, communication, munitions of war. Those were listed under employer's risk. What wasn't listed under employer's risks was under clause 17, I should say, under employer's risk, were natural catastrophes such as earthquakes, hurricane, typhoon, or volcanic activity. So going to the, if we look at the floods we had in Durban last April, those were as a result of a low pressure system that moved down through the Indian Ocean and was very near the level of a cyclone, as it would be called in the Indian Ocean. So arguably, that could well be regarded as a force majeure event. Sorry, guys. Let me get rid of these things. Sorry, these bars are just, God, don't know how to get rid of them. Okay. If a party will be prevented by performing its obligations under the contract of force majeure, then it shall give notice to the other party of the event or circumstances constituting the force majeure, and shall specify the obligation of the performance of which it will be prevented. And that notice shall be given within 14 days after the party became aware or should have been aware of the relevant event or circumstances constituting the force majeure. The party shall, having given notice, be excused such performance of such obligations for so long as force majeure prevents it from performing them. Now that's interesting, as for so long as. So force majeure would not necessarily be permanent. Okay? It could be an event which might last a period of time, and we'll come to that. So notwithstanding any other provisions of this clause, force majeure shall not apply to obligations of either party to make payments under the contract. So if payments are already owing, those cannot be obviated by the fact that a force majeure event has happened afterwards. Clause 19.3 requires each party to minimize the delay and states that they shall use all reasonable endeavors to do so. And a party may give notice to the other party when it ceases to be affected by force majeure, as we mentioned earlier. The consequences of force majeure: if the contractor prevented from performing his obligations under the contract of the force majeure and suffers delay or incurs costs by reason of the force majeure, the contractor shall be entitled, again, to subject to clause 21 to claims, to claim to an extension of time for such delay if completion is or will be delayed. So that's very relevant. I mean, you can't apply for an extension for a delay if it's not going to affect the time of completion. And then B, if the events or circumstances of the kind described in paragraphs 1 to 5 as above, and in the case of paragraphs 1 to 4 occurs in the country, the contractor shall be entitled to payment of such costs. After receiving this notice, then the engineer proceeds with these determinations. If the execution of substantially all the works in progress is prevented for continuous 84 days by reason of force majeure, which has been given under clause 19.2, or for multiple periods which total more than 140 days to the same notified force majeure, then either party may give to the other party a notice of termination of the contract. In this event, the termination shall take effect 7 days after the notice is given, and the contractor shall proceed in accordance with subclause 16.1, which concerns the cessation of work and removal of contractor's equipment. Upon such termination, the engineer should determine the value of the work done and issue a payment, which shall include the cost of plant and materials ordered for the works which have been delivered to the contractor and for which the contractor is liable to accept delivery, And this plant and material shall become the property of and be at the risk of the employer when paid for by the employer. And the contractor shall place them at the employer's disposal. Any other cost or liability which in the circumstances was reasonably incurred by the contractor in expectation of the completion of the works, and the cost and removal or the cost of removal of temporary works and contractors' equipment from the site. Sorry, I'm jumping around too much here. Okay, I think that's basically the cost of removal of temporary works and the cost of repatriation of the contractor's site and labor. Right, thank you. I'm done, Tiffany.
Let me just see if anyone has any questions for you. If anyone has any questions, you're welcome to raise your little hand and then I can allow you to speak. Okay, no, it looks like we're good. Excuse me. Okay, perfect. Thank you, Rach. Vaughan, if you're ready on your side, please. You're welcome to unmute yourself, start your video. Coming on his side, he should join us any second.
Can you hear me, Tiff?
Yeah, perfect. Hi, Vaughan.
Tiff, can you hear me?
Yes, I can. We're all good. You're good to go? Vaughan, is your volume up?
Can you hear me now?
Yes, I can hear you. You probably can't hear me. I'm not sure if your volume is up.
I can hear you.
Okay, perfect.
Can
You're
hear
good to
you.
go?
I just want to close a blind behind me quickly. Excuse me.
Yeah, certainly.
Okay, I think that takes the glare off a bit.
Perfect.
Good. Good morning, everyone. Am I cleared to go, Tiff?
Yes, you are.
Okay. Good morning, everyone. Thank you, Reg. Thank you, Norman, and welcome everyone today. I'm going to be looking at the JBCC contracts and in reference to natural disasters. I'm going to be looking at the JBCC 2007 edition 5, and I will also then be looking at the JBCC edition 2018 edition 6.2. I'm going to be referring to the contract itself, so I'm not going to be pushing up a slideshow. I'm assuming everyone has access to these contracts. If not, I can load them onto the screen and we can all view them from the on a shared screen. Okay. Here we go. Is that better? Good. The topic of natural disasters and force majeure particularly is something that's, I suppose, both topical and may become a bit more relevant when I think we get a better understanding of what this recently declared state of disaster is and what the consequences of that state of disaster are going to be. Just as a start, the Gazette and the basis for the declaration that we heard last night and what has been published in the Government Gazette talks to the same reasons that we saw and when we saw the state of disaster being imposed on the COVID epidemic, and also giving the Minister of Corporate Governance, Mrs. Lamini Zuma, authorities that she also enjoyed when she was in the same position under the previously declared state of disaster. The reason that I'm mentioning it is one of the things that I found interesting with the state of disaster that followed and states of disaster that are declared following both the COVID-19 situation and that of in consequence of natural disasters is the different ways these two forms of contract deal with the issue. In reference to the 4 standard forms, though, I think in principle, the mechanics for dealing with this type of event are generally quite similar. And we see under the 2007 JBCC agreement a slightly different regime than we see under the 2018 revision. And the primary difference between the two, it's less difference in consequence, in my opinion, and more a question of the approach to what is and determining what is or isn't a force majeure event, which would follow a natural disaster or a claim in terms of or consequent on a natural disaster. Now, the JBCC 2007 edition talks to this issue under clause 29 of the standard terms and the provisions of 2.93 particularly. We see an adjustment to that in the 2018 standard form under clause 29 again, with the introduction of a definition of what is a force majeure event. And I think, as already been pointed out, one of the things that we need to appreciate when we deal with force majeure events in our context, in South African jurisprudence, is that the force majeure as a concept is something that we've inherited largely and has been brought into and drawn into our jurisprudence by from the French codification civil law system, coded civil law system, that has been incorporated through the mechanism being introduced and brought over into contracts, particularly in our context, contracts of construction contracts and standard form construction, both the international standard forms as well as our local standard forms. So the concept of force majeure in South Africa and jurisprudence is to an extent foreign and has a similar concept, although we don't call it force majeure, which we have a relatively large amount of jurisprudence on in South Africa, and that's the concept of supervening impossibility of performance. So the concept of supervening impossibility of performance is wider than a force majeure event, in as much as the concept envisages parties' contractual obligations being suspended and or completely avoided in the event of a supervening impossibility of performance. So the cause of that supervening impossibility would have to be an objectively discernible cause that has an objective consequence. And one of the leading cases on this is an old Kroonstad municipality decision, where which happened subsequent to the Second World War and the availability of steel to the international market. So as a concept then, force majeure is something that we have introduced into our system, and the mechanism is through the incorporation into these standard forms then finds its place in South African jurisprudence, not as a doctrine, more as a condition and a term of contract. So for that reason, primarily, it's important that we understand the mechanisms and the consequences and how the mechanics of these different, or the way the contracts deal with these mechanisms, because they are introduced and incorporated via contractual terms. The JBCC standard form, as you all know, is seen several machinations and additions over the years, both in my practice and experience over the last several years. We still see both contracts being used, the 2007 edition and the 2018 edition. So in terms of the 2018 edition, the 2007, the 5th edition of the JBCC, the contract, interestingly, doesn't have a definition of what a force majeure event is. It does, however, contemplate the force majeure event, and the consequences of that event occurring are then dealt with under the provisions in relation to time, clause 29, which is the revision of date for practical completion. And to revise the date for practical completion, as you're all aware, under the JBCC regime, requires us to, follows on several causes which are identified explicitly in clause 29 of the contract. And these clauses are, or these causes rather, are relatively wide-reaching and far-reaching, and include specifically that which we have seen in, and will see when we look at the 2018 edition, of examples of events of force majeure. So, for example, one will see at 29.1.1, and I'm talking now to the 2007 edition, that in the event of adverse, or rather weather conditions affecting the works adversely, that is a cause identified as a reason for claiming an extension of time. So one sees the adverse weather conditions as one, or rather weather conditions having an adverse effect. So it doesn't talk to exceptionally adverse weather conditions, as we've seen in the reference to the FIDIC contract, but the circumstances are wider. It just talks to weather conditions. So whereas one would, under the FIDIC contract, expect an exceptionally adverse weather condition to affect the works, not necessarily be a force majeure event, one sees that weather conditions under the JBCC, to the extent that these may be force majeure type weather conditions, as we saw in the floods down in KZN, that those circumstances, provided the event is unforeseeable, which we'll talk to in a moment, the effect of those weather conditions would entitle one to claim both extension and adjustment to value. So the weather conditions, the weather conditions and the effect of weather conditions, provided they are adverse, would entitle one as well. And then if one looks to the provisions of clause 29.4, an event that neither party could prevent, and then we're given examples of this: civil commotion, riot, strike, or lockout. Traditionally, as we'll see when we look at the definition under the 2018 edition, these are traditionally examples of what a force majeure event is. So we see then under the provisions of further provisions, particularly under clause 29.3, having dealt with and identified specific circumstances or specific events or causes entitling a contractor to claim extension, under 29.3, further circumstances for which a contractor is entitled to a revision of the date for practical completion are delays to practical completion by any other cause. Let's stop there for a minute. So what we see in in clause 29.3 of the 2003 edition is a type of parachute provision under 29.3. So in as far as and in as much as the event for which one is seeking to claim, the cause, the event, the cause, the circumstance, is not a cause identified in clause 29 1.1 to 29 1.6, and then again also under 29.2, provided the cause, in other words, the cause other than those identified, is beyond the contractor's reasonable control. So there's a cause that has to be identified. Second requirement is that that cause has to be beyond the contractor's reasonable control. And again, comparing to what Reg talked through in terms of 19.1 of the FIDIC contract, the same threads are being drawn through. So there's got to be a cause or event which is beyond the contractor's reasonable control in order for that event to qualify as a basis for a claim. The event then could not have reasonably been anticipated and provided for. The language is the same, and hence I'm saying at the outset, I said that the provisions of these clauses through all of the standard forms have similar threads. So we see, although it's not specifically defined, the same tools in order to define what the force majeure event is. So again, it is beyond the reasonable control that could not have been reasonably anticipated, but importantly, and provided for. Again, similar to what we see in the FIDIC contract, and there is, besides the general common law obligation to mitigate once the event occurs, for an event to qualify under 29.3, it is an event that could not reasonably have been anticipated and provided for. So irrespective of whether one could anticipate the devastation that would follow from the huge rains that one had, the event would have to have the circumstances, the impact of that event would have had to have been provided for as well. Then lastly, it says that the principal agent shall adjust the contract value where such delay is due to the employer exercising the rights in terms of the agreement or by the default of the employer. Which is, in my view, a slightly awkward sentence in the context of what is essentially a provision for determining whether an event is a force majeure event. But we'll have a look at those consequences in a moment. So in terms of the JBCC, then, one is entitled to rely, or an event identifies as a force majeure event, although not expressly so, under clause 29.3, and to the extent that the event qualifies in terms of the definition under 29.3, alternatively, it is one of the identified causes. The entitlement then that the contractor has would be to claim both an extension of time or revision to the practical completion date and an adjustment to the contract value. Now, in terms of the 2018 JBCC contract, again, I think the additions and the changes that we see in this contract are, in my view, perhaps more cosmetic than substance. And what the 2018 provisions do is aligns the JBCC way of dealing with and particularly defining what a force majeure event is, with other standard forms. So what one sees under the 2018 edition, 6.2, we see a definition of force majeure, which is then included under the definition section under 1.1, and identifies a force majeure, defines a force majeure event, firstly, as an exceptional event or circumstance. And again, that's a common requirement across all the standard forms, that the event has to be exceptional, or the circumstance has to be exceptional. And that event or exceptional event or circumstance could not have been reasonably foreseen. Now, again, harking back to 29.3 of the earlier edition, one sees exactly the same application and different requirements in both contracts. Firstly, and then secondly, is beyond the control of the parties. Now, although that on the face of it is a movement and shift away from the 2007 requirement, where explicitly it provided that the event has to be a cause beyond the contractor's reasonable control. So here it is an event that impacts on both parties. And I think that is an important shift, because it's not just an event, and it's defined as an event that impacts on both parties, whereas under the earlier provision, the event had to be beyond the contractor's reasonable control. It's, I think, perhaps a wider definition, and I think it's there and included in the 2018 edition because of the earlier edition not dealing specifically with a force majeure event, but having to have provision for that type of event in the contract. And then lastly, and could not reasonably have been avoided or overcome. So those are the three legs of the test then to determine whether or not an event is a force majeure event. So it's defined, and we've got a very clear test. Again, a similar approach to what the draftsman under the FIDIC contract have taken. And moving on then, as in most of these contracts, it then gives examples of what a force majeure event may include. And again, very importantly, it's not a closed category, it's open-ended, with a clause providing that such an event may include, but is not limited to. Now, we then have a series of examples of what would constitute a force majeure. And even with these examples, when one comes to deal with force majeure events and the declaration of force majeure events, I know we're talking about in a specific context of a natural disaster, but the definition, I think, is always tested by particular circumstances. And the important thing to bear in mind, or to your starting point when dealing with force majeure event, is, like in most of these cases, is what does the contract expressly provide? So we see then a series of an open category of definitions of what an event, a force majeure event, may include, and expressly not limited to acts of war declared or not, invasion or hostile acts of foreign enemies, insurrection, rebellion, revolution, civil commotion, disorder. We see again on that point, which is the third bullet point under the definition of force majeure. And if one goes back to the 27 contract, one sees a definition also included as an example under clause 29.1.4, an event that neither could prevent civil commotion, riot, strike, or lockout. So under the 2007 edition, we still find the existence of a force majeure event and provision for a force majeure event, but it's not as a separate class of event. Whereas under the 2018, we've now categorized and we have a class, force majeure. The definition then goes on and talks to disorder, riot, strike, lockout by persons other than the contractor's personnel. Again, very similar to what we see in other standards, like the FIDIC contract, and there's a good reason for the exclusion, because obviously if it's within its contractor's employees, the thinking is that these employees and the contractor could have provided provided for these employees not to perform these acts. So if the lockouts are caused by persons other than employees or subcontractors, it would then qualify as a force majeure, provided, of course, that the three legs of the test are complied with and ticked off. And then we have always the sonic shockwave caused by aircraft or other aerial devices ionizing or radioactive contamination, explosive materials, except where, again, attributable to the contractor's use of such technology. And then lastly, and importantly, in the context of what we're talking about, a specific class which defines and ensures that the natural disasters are defined and are, in fact, force majeure for the contract purposes. So we see under the last bullet point of the definition then, natural catastrophe, including earthquakes, floods, hurricanes, or volcanic activity. And certainly we've seen the consequences of floods, and we recently, we're living through an event, a catastrophic earthquake event, which is prevailing in Turkey and Syria currently. And clearly in those circumstances, and by application of the definition under the 2018 JBCC contract, you would be dealing with a force majeure event. Now, the provisions then of the 2018 force majeure clauses start with the definition that we've just gone through and move on to clause 23, which deals then with the revision of the date for practical completion. So we have a specific incorporation of the definition under the clause entitling a contractor to apply and make application for a revision to the practical completion date or extension of time, which we see in reference to clause 23.1 and particularly clause 23.1.6. 23.1 then sets the basis and provides that the contractor is entitled to a revision of the PC by the principal agent without an adjustment of the contract value. So important in terms of consequence under the 2018 contract, we've now got a specific exclusion for an entitlement to adjustment for the contract value. So the contract value is not adjusted for a delay to practical completion caused by one or more of the following events. So we see the mechanism for dealing with a force majeure event then under the 2018 contract becoming more defined, more refined, and clearer. So under 23.1.6, excuse me, an event which is a force majeure event, i.e. qualifying as an event under the definition, is an event for which the contractor then would be entitled to an adjustment or revision rather of the date for practical completion without an adjustment of the contract value. So in terms of the entitlements then, as I say, under the 2018 edition, with regard to force majeure, it's very clear as to whether or not the contractor is entitled to claim both cost and time. And it's clear that in the event of it becoming and being a force majeure event, the entitlement is limited to a revision of the practical completion date. Now, the practical completion date and the clauses dealing with managing that practical completion date are still very similar in both contracts. And going back to the 2007 contract, again, having overcome this issue of or the difference between the definition of what isn't a force majeure event under the two contracts, one then looks at 29.3 and 29.1 to understand whether or not, and to what extent rather, the entitlements follow the event occurring. So again, under 29.1, the contractor is entitled to revision for the date for practical completion, and for which revision the PC shall not adjust the contract value, or delays to practical completion caused by one of the following causes. So we see the same wording and the same approach taken in the JBCC. The only difference being that under the later edition, we've got a crisp definition of what would qualify as a force majeure, whereas under the 2007 edition, we see the same definition, but not as crisply and directly defined. But the causes are still available, and should the the event occur, be it under 29.1.4 or under 29.1.1, the entitlement would then be to claim an extension or rather revision of the practical completion date, but without an adjustment to value. So if one then looks at 29.2, these are the causes that would entitle a revision to the practical completion date and for which revision the principal agent shall adjust the contract value. So this is when it becomes important to understand that the definition of force majeure in the 2018 edition is, and the placement of that where it is placed, does change, in my view, the substance of the 2007 edition. So under 29.2, one finds, for example, the requirement or the causes for example, suspension of the works, which doesn't necessarily follow a force majeure event, and very specific causes identified for which an adjustment shall be given. We then move into clause 29.3, where we see that this is, as I say, a parachute provision, which basically harks back to the definition, and I think was a precursor to the definition that we see under the 2018 edition. And the question then arises that further, that should the event as identified and as defined and referred to under 29.3, the principal agent shall adjust the contract value where such delay is due to the employer exercising his rights in terms of the agreement or by default of the employer. So the considerations then are slightly different. Under the 2018 edition, we see that there is an entitlement which is simple and straightforward, additional time, revision to PC, but not adjustment to value. The 2007 edition, in my view, opens up and has a different approach to the adjustment for value. In terms of time, again, the adjustment that is given, the revision of time, that is the revision to the practical completion date, follows the event, follows the consequence. And there's an opportunity under the provisions of 29.3 for the PA to adjust the contract value, provided that the delay caused consequent on the force majeure event, on that event for which the contractor cannot reasonably be foreseen or provided against and was beyond control, that the adjustment then to the contract value, provided is potentially available to the contractor, provided that this is due, in other words, the delay is due to the employer exercising his rights in terms of the agreement, firstly. So, which begs the next question, to the extent that a force majeure event then does occur under the 2007 edition, and the employer then determines that the works should not proceed, an instruction is given then to suspend the works. That is one of the entitlements that and a right that is available in terms of the JBCC. Now, to the extent that consequent on the event, the suspension is then ordered, in my view, there's an arguable case that the value, the contract value, should be properly adjusted. Similarly, or by default of the employer. Now, in my view, it's an awkward situation, because the very nature of a force majeure event would preclude the employer defaulting. So, for example, access to site or site works, etc., are inaccessible due to the event, or the event as a force majeure event must do, would then prevent both parties from continuing and exercising their obligations. Now, in those circumstances, I find it difficult to envisage a default by the employer, because by its very nature, that type of event would necessarily preclude the parties from performing their respective obligations, in which case, what default could the employer perform when the employer, by very nature of the act that has occurred, the event that's prevailing, cannot perform? Which, again, I think would highlights the and I'm hesitant to use the word confusion, but certainly the position that our law has taken, that if and to the extent there is supervening impossibility as an objective fact, the parties would then be excused from performing their obligations. In this case, I think the force majeure event or particularly the consequences of that type of event, because as I've mentioned, or as I've explored, force majeure is not defined, I think does lead and does open a proverbial hornet's nest when it comes to entitlements to proceed to recover effects and to recover from the impact of a force majeure event or an event occurring under 29.3. So one sees then that there's this entitlement under the later editions. On the 2018 edition, this I wouldn't say confusion, but this possible avenue that a contractor may have to pursue a claim for adjustment to the contract value, I think is well and truly closed off, and is more aligned then with what we see in standard form contracts such as the FIDIC contract, and later, as Michelle will discuss, the NEC contract. I mentioned the 2007 edition because, as I say, it's still an edition that I find certainly I come across not regularly now as much as I did in the past, but there's certainly use made of this contract form still. So whether or not the force majeure event occurs under the 2007 contract, we have a situation, I think, where one has to pay and examine the event itself with a lot more, examine the event a lot more intensely to determine whether it is an event which qualifies. To the extent that it does qualify, then one goes into the next phase of the test under 29.3, which, as I say, in terms of the new contract, the 2018 edition, we don't have that particular problem. Force majeure is always going to be an issue, I think, and as we've seen in recent times in our own context, what we saw with COVID and the pandemic and the consequences that we were faced with subsequent to the declaration of the state of disaster. We had force majeure claims, which I'm sure most of you were involved in and have seen. But we also see that with the impact of natural disasters like we've witnessed in Natal, this isn't something that's going to go away. I also think that one has to be very circumspect when you deal with force majeure events in the context of a natural disaster. I think it's more, it's clearer than it would be in other circumstances where, for example, we've seen force majeure events declared by Transnet regularly in circumstances that may not exactly be force majeure events, either under the NEC or other contracts. So one has to be very circumspect about dealing with force majeure. I find that force majeure isn't regularly, but does on occasion is kind of a default position and used as a parachute provision without people being really critical of the event itself, and more importantly, understanding what the contractual entitlements are in the event occurring. Thank you. I'm open to any questions, Tiff, if anyone has any questions or inputs or comments, should anyone have any.
Perfect. I see Uwe has raised his hand. Uwe, I'm just going to allow you to talk. If you can just unmute yourself, you're welcome to ask your question.
Good morning, all. Thank you. Thanks for letting me participate. Just a little bit of background. When we revised the 2018 edition, we consulted fairly widely with the industry as a whole and the various big insurance firms and so on, as well as the big legal firms. And that's how we, for instance, got to the term of adverse weather conditions, because it's not only inclement weather, as the 2007 version said, but it could be extreme heat, as Norman mentioned the example of Uppington earlier, or it might be unseasonable cold weather that you can't pour concrete and that sort of thing. So it was done on that basis that it is more inclusive. We also had to look at overseas documents like JCT, and for instance, NEC, that say look at weather reports over the last decade for that particular location. And we've come to the conclusion that that is relatively meaningless in the context that we're living in, because you've now got a flood in 2023, but it hasn't drained in this area for the last 10 years. Does that mean it's disqualified? So we thought that sort of overseas provision didn't make any sense. Just to give you the background of why we changed it. That still gives you the opportunity in the third part of the clause in both of them, if there's consequential damage, whether you've now agreed that you're entitled to additional time, but maybe while you were doing foundations, they got flooded and you now had to get a pump in to go and pump out the water, that you could be entitled as a contractor to claim for hiring a pump. Thank you.
Thank you, Uwe. Yeah, I think on that point, it's, force majeure is also quite interesting because there's always two legs, or generally two legs, and that's besides the immediate consequence. In other words, the prevention in performing your obligations as a result of the force majeure. There's always another leg, and that is cleaning up afterwards, and who is responsible, and on what basis are the parties responsible. Again, just as a general point, I find that sometimes the contracts aren't particularly helpful on that particular issue, and one then has to look at responsibility and provision for under the risks clauses generally, to determine what is the best course of action in those circumstances, besides the potential possible claims that one has on insurance. But there's certainly those two components over and above the time in terms of cost, the cost immediately to prevention and inability to perform. And then finally, the second leg of that is to carefully determine the costs for putting the works back into a space. And one argument that I've come across is that, to the extent that the contractor is constructing, and there's always provision in the contracts, I can't remember offhand which of the clauses of the JBCC it is, but there's also provision for and responsibility given to the contractor to take care of the works. And very often reliance is placed on that clause, because it's, to impute an obligation on the contractor, firstly to insure potentially against that type of event, but in either event, to insure would require an insurable interest, which the contractor has because of his responsibility to take care of and look out for the works. But it's not as clear as that, because the next leg of the inquiry may involve rehabilitative works to put the works into a space where you can commence where you left off. So these are all cost consequences that, in some instances, I don't think the drafting and the provisions of the force majeure events clauses that we typically encounter necessarily deal with exhaustively. Thank you.
I see Sipo also has his hand up. Sipo, I'm just going to allow you to ask your question. You can just unmute yourself.
Thank you and good morning. I just wanted to find out whether the activities of contract mafias do qualify to be force majeure events, because it's something that is happening often on big projects. Thanks. Thank you,
Sipo. Yeah, I think that it's a debate that I've had on a number of claims in the recent past, and I don't think there's a simple answer. But one would, in other words, it's yes, it is a force majeure event, or no, it's not. And again, you have to test the event against the definition, and one looks at the definition in the context of the JBCC, JBCC 2018, where you've got the three-pronged test, could not have been reasonably foreseen. So if and to the extent that the involvement of that particular mafia, let's call it, could not have reasonably foreseen, one would tick that box. Is it beyond the control of the parties, both of the parties? one of the arguments is that this mafia and the involvement of these business forums is, and the debate is, whose responsibility is it to deal with that? And I think generally now it's accepted that there's a joint responsibility, but certainly I've seen many contracts trying to shift that responsibility onto the contractor, particularly in circumstances, and I find awkwardly in circumstances where the contractor isn't the party initially who's determining the extent of local community participation, for example, or has liaised with local community, at the outset or during the preparatory stages of the contract and project. And then lastly, could not reasonably have been avoided or overcome. So what would it take to overcome, and how does one avoid it? So I think that it's a highly charged question, Sipho. And my immediate feeling, and again, it's my personal view, and again, depending on the terms of the contract, I have seen situations where employers have accepted it as a force majeure, particularly where the engagement leads into something else. So it causes lockout, it causes strike, it causes disorder, causes commotion. Where it doesn't cause that, and the impact of it is, I guess, more insidious. In other words, it doesn't necessarily stop the works. It perhaps doesn't go far enough to be qualify as a force majeure. And then as an overarching comment, again, it doesn't really answer the problem, but to the extent that one can foresee the involvement of a mafia, of a business forum that is largely a mafia, one would then also perhaps be disqualified because you could have foreseen it. So, in an area where it is common knowledge that projects have been influenced, have been interrupted, have suffered the exposure to these kind of organizations, could a contractor not reasonably have foreseen that this would have happened? So I don't think it's a simple answer. And I think that in circumstances where I've seen anyway, where it moves into a space where there's commotion, disorder, rioting, and access is prevented, etc. It's perhaps a little bit more clearer that it could be a force majeure. But where it is more insidious and happens at different levels, it becomes more difficult. So I would look to dealing with that not as a force majeure event generally. Thank you, Sipho.
Sorry, I see Uwe's raised his hand again. Uwe?
Yes, thank you. There's a CIDB guideline that was published, I think, 20 years ago. And I can't remember the exact title, but Ewan actually wrote a paper on it not so long ago. That's worth looking at. Yeah, thank you, Uwe. But as I say, this is a very charged issue, and I don't think default to a force majeure clause is a quick get out of jail free or get out of jail card. I think it's not as simple as that.
Okay, good. Perfect. I think those are all the questions for you, Vaughan.
Thank you, everyone. I hope this has been an informative session. And again, I just, and again, it might just be from where I talk from. But we mustn't forget to pay particular and specific attention to the contract when we deal with these type of issues. Thank you. Thank you, Tiff. Owen, thank you very much. And everyone else, thank you.
Yeah, we're handing over to Michelle now.
Okay, perfect. Thanks, guys. Hi, everybody. I'm going to be speaking to you about natural disasters under the NEC. So I'm just going to share my screen. I hope I get the right one. Tiff, can you see that? I think that might be the wrong one.
That's perfect. I can see it. Is that your correct presentation?
Yes, it is. Okay, great. I'm just moving things around so I can look at it on my second screen. Okay. There we go. So just to re-emphasize what Vaughan had to say, I think to nobody's surprise, under the NEC, we're going to be talking about principles that everybody generally understands to be relating to force majeure. But this is not a principle in the South African common law in and of itself. So what we're dealing with is principles set down by the provisions of the contract. So each contract deals with the force majeure principles slightly differently. So we need to pay particular attention to what the wording of the contract says. We shouldn't get complacent and say, well, I understand a force majeure event under FIDIC. I'll just apply those principles across to the NEC. It doesn't work that way. We need to understand the wording of each particular contract. Okay, so with that in mind, I'm going to take you through the provisions in the NEC. You'll see I've just typed out the provision of the contract that I want to direct us to. Some of the words are in blue. So the white wording is the NEC 3, and I've just added the blue wording from the NEC 4. There isn't a whole lot of difference, which is what has enabled me to do it in the time that's available. Okay, so you'll see, first of all, the NEC does not refer to force majeure specifically. It doesn't contain those words. It's referring to it as prevention. Now, prevention in the NEC is not to be confused with the UK prevention principle that has something completely different to do with penalties. Just that is the word we are using under the NEC document. So if we look at the definition and how the contract describes it, we don't go directly to the claims clause. We first go to clause 19, prevention. If an event occurs which stops the contractor completing, under the NEC 3, it's the works, and under the NEC 4, it's the whole of the works. Obviously, just a clarification, there may have been some dispute as to whether just the wording alone, the works, is the whole of the works or a portion thereof. Under the NEC 4, they're clarifying it applies to stopping the contractor completing the whole of the works, or stops the contractor completing the whole of the works by the date for planned completion shown on the accepted program. So there's a couple of important words there. The first being that it is the works or the whole of the works. That word or, so you don't have to comply with both requirements, it's one or the other. That's quite important because if you have a look at the second leg, it's talking about the date for planned completion shown on the accepted program. Issues with the accepted program and the program not being properly prepared and drafted are often present difficulty for contractors in claiming under the NEC. Most of the claims clauses or compensation events under the NEC refer to an effect on the accepted program. And if the program isn't properly prepared or drafted, that can put a spanner in the claim itself. So note that wording. Stops the whole of the work, the contractor completing the whole of the works, or stops the contractor completing the whole of the works by the date for planned completion shown on the accepted program. And so this is also a requirement. Neither party could prevent. So note that that's placed on not just as in some of the other contracts, one or the other party, usually the contractor, it's placed on both parties. And again, so note that's an additional requirement, it's not an option. An experienced contractor would have judged at the contract date. So not after the contract date, at the contract date, to have such a small chance of occurring that it would have been unreasonable for him to have allowed for it. So there's a couple of things we need to note there. First of all, it's an objective test. So it's not what this contractor, what you as the contractor would have judged to be unreasonable for you to have allowed for. It's what an experienced contractor in general in the industry. It's not specific to the party who is named as the contractor in this particular contract. And also that word, the contract date. So they would have judged at the contract date. Perhaps we're talking about natural disasters, so it's a bit different, but if we were to refer to the community unrest or the construction mafia issue that often comes up, it's a little bit clearer because some contractors entered into, before this became a common thing, if you'd entered into the contract at that stage, an experienced contractor would have judged it to be a very small chance of occurring. And then you would fall under this definition. But if you'd entered into the contract, post the construction mafia era, where everybody is aware and expects something like this to happen, you would no longer be falling within this definition, because an experienced contractor would have judged it to have a reasonable prospect of occurring. And then this prevention principle, this prevention clause wouldn't be applicable to your circumstances. And then the very last line at the bottom, the project manager gives an instruction to the contractor stating how he is to deal with the event. So that's quite important. It actually places an obligation on the project manager. It's not an option. The project manager actually has an obligation to instruct the contractor what he needs to do when this natural disaster happens. So bear that in mind as we go forward and we look at how we can then get our extensions of time. Okay, so jumping right into the compensation events, I think everybody knows under the NEC, all of your compensation events are listed under clause 60.1. The one of most relevance that we're looking at here is 60.1 in brackets 19. You'll see the wording is of clause 19, prevention clause 19 is reflected. It's very similar in clause 60.1 in brackets 19, which makes it a compensation event. But we need to pay attention to the wording again. It is a compensation event if it stops the contractor completing the works or the whole of the works under the NEC 4, or stops the contractor completing the works by the date for planned completion shown on the accepted program. We've discussed that, and which neither party could prevent. An experienced contractor would have judged at the contract date to have such a small chance of occurring that it would have been unreasonable for him to have allowed for it. And so now we know those 3 bullet points at the bottom all have to apply. It's not optional. It's not one of the other compensation events stated in the contract. So that becomes quite important when, let's say, it's rain, like we had in Durban with our floods, and it's an event that would fall under, I'll go to the next slide, the weather measurements clause. So under 60.1, number 13 in brackets, clause 13 in brackets deals with the weather measurement. And I've just put it in just to give you an example of when it would not be a 60.119 claim, because it falls under another compensation event, such as a weather measurement, which is recorded within a calendar month before the completion date for the whole of the works, and at the place stated in the contract data, the value of which, by comparison with the weather data, is shown to occur on average less frequently than once in 10 years. Okay, so I'm not going to delve into the calculations of the weather measurement, but that is a consideration when deciding under which clause we are claiming for our natural disaster under the NEC. You'll see I skipped a slide. So another compensation event, 60.11, could also be relevant. You'll recall back to our clause 19 prevention clause. It obliges the project manager to give an instruction to the contractor on how they're going to deal with their prevention event. If the instruction changes the works information or the scope under the NEC 4, and it is not one of those accepted circumstances, then that instruction itself is a compensation event. So it's quite important for you to identify which clause you're claiming under, or you can claim them one or the other or both, and you can say it's in the alternative. But it's important to look at the wording, and it's important to understand where your entitlement arises from. Okay, so just those 3 compensation events are the main ones I felt I should mention to you. Just very briefly, looking at, and I believe Norman delved into it, and Vaughan delved into it a little bit as well, where we'd be looking at risks and we'd be looking at insurance cover. It's obviously not going to give us, this is not dealing with an extension of time. This is going to be dealing with actual damage or loss to the site and the costs of that. So under the NEC 3, it's termed contractors' risks. Under the NEC 4, it's contractors' liabilities. Under the NEC 3, the contractors' risks are from the starting date until the defect certificate has been issued, the risks which are not carried by the employer are carried by the contractor. So there's quite a limited list of risks under clause 80, somewhere under clause 80, dealing with what are employer's risks. Anything that is not listed there is now going to be a contractor's risk. Under the NEC 4, they've evolved that clause a little bit. They've now listed, there's a list of 3 or 4 bullet points. I've only quoted the one that's relevant, which are now contractors' liabilities. And one of them is loss of or damage to the works, plant, materials, and equipment. So we need to bear that in mind. And then we look at clause 84 under the NEC 3 or 83 under the NEC 4. The contractor provides the insurances stated in the insurance table, except any insurance which the employer or client is to provide as stated in the contract data. And the contractor provides additional insurances as stated in the contract data. Okay, so in our minds, I think we would have made the connection. If the contractor is liable for a risk, the contractor will be required most likely to insure. So I've just done a very terrible copy and paste from the NEC 3 and the NEC 4, just so you can see the insurance table. So you'll see under the NEC 3, it's broken up into 2 parts. Loss of or damage to the works, plant and materials, loss of or damage to the equipment, the contractor is required to insure. Under the NEC 4, there's the same thing, loss of or damage to the works, plant and materials, loss of damage to the equipment. Right. Just having dealt with that insurance aspect briefly, I won't delve into it in too much detail. It's not really my area of expertise. Just taking you then further to the termination clause, and the reason I've done that, if you have a look at the wording there, you'll recognize it. It is almost identical to the wording you get in clause 19, the prevention clause, and clause 60.1 in brackets 19, the claims clause. And it says that the employer, note that it's not the contractor, this is at the election of the employer or the client only, may terminate if an event occurs which stops the contractor completing the whole of the works or stops the contractor completing the whole of the works by the date for planned completion shown on the accepted program. And this is an important part, and this is different, and is forecast. Note the word forecast, we're looking forward. It's not that it's already happened, to delay completion of the whole of the works by more than 13 weeks. So if your natural disaster is forecast, it's not that you've waited the first 13 weeks, it's that the parties or the project manager has looked at this event, this natural disaster, and said, you know, we're not going to be working again within 13 weeks. There's been an earthquake, the land has subsided, the infrastructure is gone, there's no more roads for access. It's going to take us longer than 13 weeks to get back on track. The employer has the option, only the employer, not the contractor, to terminate the contract. They would then essentially make an application to the project manager, who assesses whether they agree with that reason for termination and then issues a termination certificate. The contractor doesn't have that option because they have a claims clause. If the employer elects not to terminate, they're allowing the contractor to claim their extension of time and their additional costs through the claims clauses. But note that the clause continues, it's wording that we recognize and which neither party could prevent, and an experienced contractor would have judged at the contract date to have such a small chance of occurring that it would have been unreasonable to have allowed for it. You'll note there's a little strike through there. That's the difference between the NEC 3 and the NEC 4 wording. We recognize those words. We've unpacked what an experienced contractor means and how we need to look at that from an objective standard. And you'll see there that's R21, so it's reason 21 for termination. Now, what are the consequences of a termination for this? I've done another awful little copy and paste. You look to the termination table. Reason 21 says the parties must follow procedures 1 and 4, and the contractor gets paid amounts A1 and A2. So if a natural disaster happens, the employer, instead of allowing the contractor to claim their extension of time and their additional costs, believes, and the project manager agrees, that this event will delay the works by more than 13 weeks, can elect to terminate, and then he only has to pay the contractor amounts A1 and A2. And I've put that on the final slide. You'll see there's very little difference between the NEC 3 and NEC 4. A1 is an amount due assessed for normal payments, the defined cost for plant materials within the working areas or to which the employer has title and of which the contractor has to accept delivery. Other defined cost reasonably incurred in expectation of completing the whole of the works, any amounts retained by the employer, and a deduction of any unrepaid balance of an advance payment. So that's a very stock standard assessment. And then amount A2, the forecast defined cost of removing the equipment. That's all the contractor is going to get paid if the employer elects to terminate on the grounds of prevention or what the event that we're talking about now, some kind of natural disaster. Obviously, the amount that the contractor would want, the A4 direct fee percentage, which would essentially be their loss of profit, isn't in that payment. Really because a natural disaster isn't to be laid at the feet of either party. You'll note from the definition, neither party could prevent. So it's not really that we're laying blame on either party for having allowed this to happen or failing to prevent it. Otherwise, it wouldn't fall into that definition. It's essentially a bit of a shared risk between the parties. Okay, so that's my very brief slideshow. Are there any questions?
Mish, I see Mike has raised his hand. Mike, I'm just going to unmute you.
Thanks. I'd be very wary of tying foreseeability to experience. Experience is a time finite thing. Foreseeability isn't. If you have 10 years of experience, you witness X amount of events. If you have 20 years, you witness 2 times X. So the foreseeability cannot be an absolute measure, or experience cannot be an absolute measure of foreseeability. I mean, if you look at our law of delict, it's actually tied into what the parties foresee, not what an experienced party would have foreseen. And more so in the South African context, where experienced contractor are few and far between, and the state is certainly trying to employ people or contractors who certainly do not have experience and build up experience over time. So for me, it's a very dangerous territory, tying foreseeability to experience.
Yeah, look, I mean, we're bound by the terms of the clauses. So the clause relates to an experienced contractor. So that's the test that we're going to be applying. But we're obviously going to get a debate about what exactly we think an experienced contractor would have predicted or foreseen in the circumstances. That's where we're going to be making all of our money, dealing with those disputes on behalf of our clients. Thanks, Mike. Any other questions?
I'm just checking the Q&A box. No, I think that's it.
Great, I'm off the hook.
Yeah. Okay. No, thanks, Michelle.
Welcome.
Norman, I don't know if you have any closing comments or.
Just to thank you very much, Michelle, Reg, Vaughan, for the input. And I think that broadly all 4 forms of contract deal with issues similarly. So there's a common thread that runs through all of them. But I suppose really the proof of the pudding is, as Michelle says, when the claims start rolling in, and then you've got to see how you deal with them. I mean, there is no doubt that we're going to face floods, cyclones, earthquakes, who knows what all else in the future. And just how the contracts deal with them is going to be the interesting part. mean, at the end of the day, there should be a fair allocation of risk. But thanks everyone for attending the session. And our next session is on the 3rd of March, where hopefully we're going to go through the updated GCC 2015, which is called for the purposes of this meeting is called GCC 2023. So hopefully that will be quite interesting as well. But thanks everyone, much appreciated. And Tiffany, once again, thank you for your organization.
Yeah, not a problem. Thank you. And we will get all of the presentations and the documents together that have been presented today, and we'll send those through to all delegates.
Thank you, Tiffany.
All right. Thank you, everyone.
Thanks, Tiff. Thank you, everybody. Have a
Bye
good
now.
day.